Hello, everyone. My name is Teresa Mugadza, a lawyer. Welcome to the Careers Channel. On today's episode, I'm going to share with you a presentation I made to my church on wills and inheritance. Please enjoy, and please remember to always speak to a lawyer. Thank you. Thank you very much, Pastor, and good evening, saints. Good evening, visitors. I see there are a few names I'm not familiar with. And as Pastor says, tonight I'm going to talk about wills, and I'll also speak about trusts. Now, I want to say that when I'm speaking to Christians, I always say that one of the things that we have learned, at least in Celebration Church Ministries, is that we must be organized. So I believe that I'm speaking to people who are part of organizing their lives. And wills are one of those ways in which you organize your lives, particularly for the afterlife, but also for those that you care about the most. And I will start to talk about wills and what a will is. Many times when I speak to people about wills and inheritance, people think that it's very complicated. It's actually not. And a will is something that anybody really should be able to do for themselves without putting too much thought into in terms of, the legalities, because it's actually a very simple document. In the simplest of terms, a will basically is a declaration that you make on how you want your estate or the properties that you own. And by property, we mean everything immovable, movable property. We can talk about that, what that is at a later stage. And according to the laws of the jurisdictions that I am privileged to be in, Zimbabwean by training and operating in Kenya, anybody really over the age of 16, in the case of Zimbabwe, and the age of 18, in the case of Kenya, can draft a will. Now, as I said, a will in the simplest terms is a document that says this is what I would like to happen to my estate or to my property in the event that I'm no longer available to make those decisions or to make those declarations around what I would like to see. Now, for a will to be valid in both jurisdictions, it must be proven that this will has been drafted by a person who's of a sound mind. Why this is important is oftentimes, as Pastor referenced to the scripture, people tend to want to write their wills when they're on their deathbed. And sometimes that opens a will to contestation or to dispute, because the question of how sound were you at that point comes into play. So ideally, you should write your will when you are healthy, when there's nothing wrong with you, and you just say, should I not be here tomorrow? This is how I'd like my estate to be managed. So it must be a will that cannot be contested for, people saying, oh, maybe the wife was pressuring or the husband was pressuring to say, now, look, you are sick, you're on a deathbed. Can you do something about your estate to protect us or to protect the children? So very basically, a will should be written down. It should be written in the best scenario at a time when you are not under duress, when you are not under any fear or under pressure. And you must have very clear intentions that it speaks to what you'd like to happen. And wills can be what you'd like to happen, from how you'd like your funeral to be conducted, to how you'd like your property distributed, to who you would like to be the person that's responsible for actually administering that estate and the distribution. So usually a will contain a few things. So the basic things, of course, you are going to list, this is me, Teresa Mugadza, of a sound mind, on such and such a date. I'm writing this will to distribute my property in the event of my demise. Ideally, in your will, you should also nominate what we call an executor, who is the administrator of the estate, the person who will be responsible for taking care of the business related to the estate. And then you can also then go into now the distribution of the property itself. In your will, again, that's where you nominate who your beneficiaries are. So you want to nominate who are the people that you want to benefit from your estate. And for those with minor children, it's also the opportunity to appoint the people that you'd like to be guardians over the children. Because sometimes it does happen that parents are not there, and then it becomes the business of the law to determine who becomes guardian. So you can also use a will to actually nominate guardians for minor children where appropriate. And of course, to then put out a distribution plan in terms of who takes what. A will, however, cannot provide for illegality. So what do we mean by illegality? So for example, you can't say in my will, if I owe money to anybody, by the time that I die, it can't be paid. You cannot put that in your will. Or if you are involved, for argument's sake, in criminal enterprise, you can't then say, I would like to pass on my criminal enterprise to X and Y, because that is providing for illegality. So you cannot avoid debt. You cannot provide for illegality. The beauty of writing a will when you are in your sound mind is that you can amend it as you go. So, for example, if you write a will this year, you have so much property, maybe you have 2 houses. In another 5 years, you've acquired more property. You are able to amend a will, and you do that through a legal instrument that's called a codicil. Ideally, your will should be with somebody. You should have a copy. Of course, you can keep one. I know that in African families, the questions of wills are very contentious. So people sometimes don't want to be known that they have wills. But ideally, you should have somebody who has a copy of the will, and preferably somebody who's not a beneficiary of the will. So you'll find that the encouragement, of course, I speak as a lawyer, the encouragement is deposit your will with a lawyer, or you can keep it in a safe deposit box in the bank, or you can leave it with a trusted person, including your pastor, or, a trusted family friend who can then produce it upon your demise. I'll try and cruise through because there's quite a bit I want to speak about, so we can take questions at the end. So basically, what happens when you have a will and then you pass on? Because I think that's the question. A lot of people say, we hear there was a will. What actually happens? I will speak about the processes in both Kenya and Zimbabwe, so that what I'm speaking about is a very shortened version of the process. You will need to actually sit down with a lawyer practicing in either jurisdiction or whichever country you're operating from to actually then guide you on what needs to be done. So supposing you then pass away and you have a will, the procedure in the case of Zimbabwe is, of course, the will together with the death certificate and a list of the assets is then lodged with the Master of the High Court. The Master of the High Court in Zimbabwe is responsible for administration of deceased estates. So you take the will together with the death certificate, together with the inventory of the assets, if they are known, and you deposit that with the master. Now, what the master will do, because you've nominated an executor in the will, is they'll call what they call edict meeting. The master will put a notice in the government gazette to say, in the estate of so and so, we have a will, we are proposing an edict meeting on such and such a date, so that all other interested persons may also be part of that conversation. When the edict meeting is held, the Master of the High Court basically confirms that there is a will and that this is the person that has been nominated the executor. Sometimes you'll find that families contest, or they've given this lawyer, we don't like this lawyer because maybe the lawyer, for argument's sake, maybe they were involved in some, commercial deal that didn't go very well with the family and they want to contest it. So the idea is that everybody is aware of who is the administrator. If there is no dispute, the Master of the High Court will confirm the executor by giving them what are called letters of administration. Letters of administration are what allows now the executor, for example, to go to your bank, to get your latest bank statement, to stop all transaction on your banks, to go to people that you owed money, to get the latest statements of what you owed, should you have any loans or mortgages, to also go to people that owed you money if you are in business, and to be able to say what are the outstanding accounts, so that we come together with the net value of the estate. In the case of Zimbabwe and also in the case of Kenya, what usually happens is, supposing the deceased person was married in terms of the civil law, the law is that even in terms of the customary law, particularly in the case of both Zimbabwe and Kenya, there is what they call a protection of the spouse by law. So even though the estate will involve the matrimonial home and other what we call residual estate, usually that is protected for the spouse, but we'll talk about that a little bit later. So because of the letters of administration, your executor basically now has the role of, as I said, collecting what you owe, collecting what you were owed, and putting it all together. Once that is done, because they have letters of administration, they also have the responsibility to pay whatever is outstanding. So for example, if you had a mortgage, when they put together everything that's in the estate, they have to pay off the mortgage. Sometimes this is how you hear, the person died and then the house had to be sold because they had to pay mortgages. And then whatever is left is then distributed to the beneficiaries as stipulated in the will. And as I said initially, also providing for those legal provisions that are there for, the spouse, for the children, and other persons that may be nominated as beneficiaries in the will. Now, once that, the payments, as it were, the administration is done and the will is the assets are distributed, what you then have is what we call a liquidation and distribution account, which must be published again in Government Gazette so that everybody sees that this estate is now being wound up and this is the person who's responsible, so that in case there are any claims that might have been missed or fallen through the cracks, they also come back and alert the Master of the High Court to that issue. Once the notice for liquidation goes out and there's no contestation, it's considered approved, distribution is made, and the estate management is closed. In the case of Kenya, there is no Master of the High Court. So what usually happens is the family division of the High Court is who is responsible for administration of testate succession. That's what we call inheritance where there's a will. It's called testate succession. So what then happens is when somebody dies, in the case of Kenya, the executor who has the will apply for what is called a grant of probate, or the authority to act on behalf of the deceased person to implement what they've put in the will. The application for probate is made to the High Court, and it is again published in the Government Gazette. Pretty much like the Zimbabwean situation, it will run on the Government Gazette for about 30 days. If there are no objections to the executor getting the grant of probate, it is then granted by the High Court, the family division. And once that has been done, the executor is also given letters of administration, which is basically the grant to then act. And again, they act, as I said, on ensuring that they collect whatever is owed to the estate, and they also pay out what the estate owes. And once that is done, they come up to the court now with what they call the distribution plan. When they've paid everything that's outstanding, a distribution plan is drawn up. Again, it is put out in the Gazette so that all interested parties are aware. If there is no contestation, the distribution is confirmed. Now, this is the ideal situation, but we know that processes can be contested at any point. So people have been known to contest the will. They've been known to contest to say, oh, my brother would never have a will that, does not provide for my inheritance. We have even seen people contest the executor who's been appointed to administer the estate. I don't know how many of you follow the local news, but you recall that last year one of the judges in the High Court died and appointed his brother an executor, and the family are in court fighting on why that particular individual has been nominated as an executor. So there are many stages at which a will can be contested, which is why I was saying it is important that when you do draft your will, try as much as possible to ring fence it against where the contestation may be. Contestation is usually around who are the beneficiaries, who has been nominated the executor, and who have been nominated to receive provisions from the estate. But I'm happy to take questions to talk about this a little later. Maybe before we go to trust, are there any burning questions on wills? Because very briefly, that's what it is. I will talk about intestate succession, which is succession when there is no will, towards the very end, because I'm talking to born-again, spirit-filled people who should have wills. I do not anticipate that we are going to die intestate. So are there any questions on the wills before we go into trusts? Thanks, Doc. So according to the law now, children born in wedlock and out of wedlock have a right to equally inherit. Unlike in previous times where if there was a civil marriage, children born out of wedlock did not have a right to inherit. In Zimbabwe, at least, the Supreme Court actually has ruled that it is unconstitutional to deny children of right to inheritance because they are born out of wedlock. So they are all entitled to inherit what would be considered a child's share of their father's inheritance. Thanks, Pastor Memory. If I heard the question correctly, can a will that's been written when somebody is incapacitated by ill health be contested? Certainly, it can be contested. I think when I started at the beginning, I said that one of the things that you must do as much as possible is try and write your will when you're of a sound mind. You are not under duress because you are fearing that you may be dying in the next week or two, because then we say your reasoning capacity is affected. So to the extent possible, the encouragement is write a will when you're of a sound mind. And indeed, a second will written, particularly when somebody is incapacitated, when they are sick, especially when they think they are going to die, is a will that can be contested, and it would be, legal grounds to contest, because you can contest that they were not exactly of a sound mind. They were now being driven by fear, or they were being driven by concerns, which may not necessarily have been concerns had they been of a sound mind. So it is a will that can be contested. Okay, so I'll take them one at a time. Can a will be oral? Yes, a will can be oral, but in Zimbabwe, the law is that there is a monetary limit to an oral will. So up until very recently, you could not have an oral will that provided for property total exceeding $10,000. So ideally, a will should be written, and I think I did mention that at the beginning, that ideally, your will should be a written will. Secondly, if you're operating in various jurisdictions, do you need a will for each jurisdiction? No, you don't. You can do one will, which is why initially I said that it's important to be able to draft your will and appoint an executor. Ideally, if you appoint a legal practitioner or a legal firm, they'll then be able to work across multiple legal jurisdictions. So you could write your will, have it lodged, say, with the Master of the High Court in Zimbabwe. You have properties in Kenya, you have properties in the United Kingdom. The lawyers will be able to then track and follow through. A lot of us are working in different countries. We hold money offshore. Your lawyers will be able to do that for you. So this is why the encouragement is, to the extent possible, write a will, preferably nominate an executor who has the capacity and understanding of the law to be able to operate cross-jurisdictionally should the need arise, because they also have the responsibility to then put notices when the government gazette is running, for example, in Zimbabwe, to say we are doing the estate of, X. They will be able to put notices, in the local newspapers. Just a couple of weeks ago, I was going through the classifieds. Unfortunately, it's a habit you pick when you're a lawyer. And I noticed that there were a couple of estates that were advertised in Kenyan newspapers. One was an Italian person. The other one was a French person who apparently, I think at some point had lived in Kenya. So when the executors are now managing the estate from outside of Kenya, they still have an obligation to put the notices just in case there are issues that pertain to the estate there. That was the second question. The third question related to beneficiaries. Ideally, your will should provide for all your beneficiaries. So for argument's sake, if you do your will, Sister Precious, and you nominate 3 beneficiaries and you forget to nominate one, but they are nominated as a beneficiary in, for example, a policy at work, there would still be that obligation because your employer has the contract with you. So there would be an obligation for the employer to do right by that particular individual. However, if you have then put in, say, my insurance policy that my employer holds, and you exclude an individual who may be included at the workplace, that might create some legal challenges for you in terms of whether or not your executor understands their responsibilities to all your beneficiaries. I hope that helps. Dr. Welcome had asked how much it costs to draft a will. A will can cost you money, but it can also not cost you money. As I said, you can draft a will by yourself, really. You don't have to pay anybody. It's always better to have it done by a professional, of course, because then they get to take care of all the legal loopholes that I'm making reference to. I find that it depends on where you go. So if you go to law firms, you'll find that if you go to law firm X, they might charge you a certain amount of money. If you go to law firm Y, they'll charge you a different amount of money. My advice is always shop around before you decide, you settle on who you're going to get to do your will. Shop around in the first instance, but also make sure that you're dealing with a reputable law firm, so that you also don't deal with fly-by-night firms that maybe by the time something happens to you, the law firm has ceased to exist. So the more established, the better. That would be the advice. So you can contest a will if you've been excluded as an adult child, because, as I initially said, according to the law of inheritance generally, the first beneficiaries are, in the case of a married person, their spouse and their children, in that order, before you go to parents and to siblings. So if other adult children are benefiting, you can contest and you can make a claim. So you may not necessarily contest, but you certainly can make a claim against the estate for your right if other children of the deceased person are making claims to that estate. Unfortunately, those things do happen, and that's why we have regulators, right? So Zimbabwe is the Law Society of Zimbabwe, Kenya is the Law Society of Kenya. By the time you're winding up a law firm, there's an obligation to hand over existing or outstanding legal matters to other legal practitioners. So what you may find is, if, for example, you got a Moyo and Moyo who then wound up, Moyo and Moyo might have transferred the files to another firm. So the advice would be to go to the law society of the relevant country and find out, who they transferred their outstanding cases to. But generally, lawyer firms also have a responsibility, should they be winding up, to notify their clients that we are winding up, we are proposing moving files to X or Y. Is that acceptable, or do you want to find an alternative lawyer yourself? So there's also that opportunity that, in fact, your lawyers can tell you, we are facing business challenges, we are moving on, would like to transfer you to X, or do you want to choose where you would rather go? So there's also that opportunity. But sometimes it happens that, for misconduct or for any other reason, particularly the sole proprietor law firms, if they are struck off the roll, for instance, of course, Law Society comes in to administer that law firm and to wind it up. And they should ideally reach out to clients. But sometimes things do fall through the cracks. If things do fall through the cracks and you get to a point where you now need to follow through, your best bet is to go through the Law Society. Very quickly, we will talk about trusts. So trusts are very interesting in that in the last, when I started practicing law, Pastor Gift was saying I'm a senior advocate. Last year, March, marked 30 years of being admitted as a legal practitioner. So I am a senior practitioner. And it's very interesting that when I started the practice of law way back then in 1996, we didn't see so much of trusts, particularly to manage matters of family wealth and to manage inheritance. But increasingly, it's becoming quite popular. And I think we'll talk about why it's becoming popular. Maybe also then not so many people had much to distribute and to give over. So a trust document, pretty much like a will, is a legally binding document. The difference with a trust document and a will is that a trust document establishes a body corporate. So a body corporate is a body or an organization that stands on its own. A will says, I, Teresa Mugadza, am giving X and Y to my children and grandchildren. A trust establishes a separate legal entity that owns property in its own right, manages property in its own right, and it has the capacity to transact, acquire property, distribute property in its own right as if it were an individual. In Kenya and Zimbabwe, the law on trust is quite interesting because in Zimbabwe, the law of trust is largely through what we call the common law or case law. So we actually don't have an act that specifically deals with trusts. Unlike in Kenya, where you have the Trustees Perpetual Succession Act, we have the Trustee Act, we have the Trusts of Land Act. So we have acts of parliament legislation that actually addresses trusts. In Zimbabwe, it's largely common law. So you may find that you can establish a trust by notarial deed. It's done by a lawyer who's a notary public. And you basically lodge it with the master of the High Court or with the registrar of deeds, depending on what the issues that you are providing for in that trust deed are, or you may register it with the Register of Societies if it's a charitable trust. So that is the difference. In Zimbabwe, the law is much more common law, case law. In Kenya, it's more legislated. So that is the first thing to note. As I said, the trust is a body corporate. And because it's a body corporate, it usually explains itself like a constitution. So think of a trust deed as a constitution that says, we, the founders or the trustees, would like to set up this trust to do X and Y, and the beneficiaries of the trustees are A, B, and C. For those of you that have worked in the non-governmental sector for a long time, you will understand that a lot of organizations are actually established by trust deed. So they set out, who the founders are, what the objectives of the trust were, who are the intended beneficiaries, how are finances to be managed, how are properties to be managed, and they even speak to how they will be wound up if they're going to be wound up. In the context of family management of wealth and in the context of inheritance, trusts are different in that a lot of them are actually created in perpetuity and they're irrevocable. In other words, they outlive the trustees. Sometimes they might even outlive the beneficiaries because they're intended to exist for that long. So that is the first thing to say about trusts. The second thing is to say in the context of this discussion, we were talking about wills and managing wealth. A lot of trusts are established usually for purposes of as a wealth management vehicle. And they'll also provide for protection of the assets of the trust. A trust deed should also stipulate who the founders or the persons establishing the trust are, and of course who the trustees or the administrators of the trust are. So think of the trustees as like a board of directors, the people who take care of the business of the trust. And then, of course, the trust must also very clearly stipulate what property is in the trust. So it's one thing to say, we are married husband and wife, we are creating a family trust. You can create a family trust, but if you don't stipulate what property belongs to the trust, it doesn't follow that you are married and you own a house, it falls into the trust. You must actually deliberately donate. As the owners of the property, you must donate it to the trust so that it becomes trust property. And of course, you must also then clearly stipulate who the beneficiaries of the trust are. Now, in terms of procedures for trusts, maybe before we go to the procedures, just to note that there are different trusts that are established. And it's interesting that in the case of both Kenya and Zimbabwe, there are quite a number of similarities on the trusts. So we have what are called family trusts, the ones that are quite popular now, where a couple will decide we are going to create a trust so that we don't have issues with inheritance, and whatever we own, we immediately donate it to the trust and it becomes part of trust property. You also have, of course, charitable trusts. I did speak about charitable trusts for public benefit, which are the NGOs. You also have what are called testamentary trusts. Testamentary trusts are established by wills. So often what people will do, you find that these people that have a lot of money, or even if you don't have a lot of money, it's something that you can do for your, for your, what you call the people that succeed you, your descendants. You can actually set up a testamentary trust as part of your will to say, my will says whatever I own will be owned by a trust. So once the execution of my estate is done, whatever is in my estate, the residue, will now be put into a trust called the Teresa Mugadza Trust for the benefit of all my descendants in perpetuity. So that is what a testamentary trust is. And then, of course, what we call the inter vivos trusts, or the trusts that are usually set up during the lifetime of the person, which is what a lot of the family trusts that we're talking about are, because usually people are still alive, they are still acquiring property, and then they are putting them in the family trusts. Now, as I said, because a trust deed is like a constitution, it must be written down. So you don't have the flexibility of with a will, you can speak it by word of mouth. It actually must be written down. And your trust deed must be very clear on the reason for its existence. Why do you have a trust deed? Is it because you want to put all your property to benefit certain beneficiaries? So you must clearly stipulate the reason that you're setting up the trust itself. In the case of both Kenya and Zimbabwe, our tax people like to take their pound of flesh. So it's important that you register the trust with both Zimbra or KRA, depending on where you've established the trust itself. In the case of Kenya, if land is involved, or if you're going to donate land into the trust must also be registered with the Lands Registry in terms of the Trusts Lands Act. So there's an obligation there to say, in addition to registering it, with the registrar, you also must get it registered with the Land Registry because of the land component. And of course, charitable trusts in both countries must be registered with the Registrar of Documents. In the case of Kenya, in Zimbabwe, it's the Registrar of Societies. For those of you that have been following the PVO Act, that's what it's about. All trusts must be registered. I think for purposes of moving on, I want to quickly move on from trust because, as I said, just think about it as a constitution that establishes a body corporate to manage wealth during your lifetime and past your lifetime. Now, very quickly, because I see that we have 8 minutes and we might have some questions, what are the benefits of a trust? Trusts are better for management of family wealth because they provide protection of what is owned by the family corporately. And they're especially beneficial where maybe you have vulnerable members of the family, including children, who, if they had to wait for an inheritance process, might be disadvantaged. I'll give an example. Unless your will is very clear on how the distribution of the estate is going to happen, what might happen is, even where you have a will, for a period, your beneficiaries may not be able to access assets from the estate because the estate is going through administration. I know that if you have a good administrator, they might pay for what are necessary living expenses, right? But if you don't have a good administrator, you may find that you don't have access to the benefits of the estate. So the beauty of a trust is because it's a body corporate already operating like a company. Whether you are there or not, your beneficiaries are still able to access their benefits from the trust. That is the first, I think, benefit. Of course, the second one, as I said, is that, it's because you do it while you are alive, you are able to then clearly articulate who benefits what. Unlike a will where that can be contested to say, oh, I'm a child of the deceased, I have a right. If a trust exists, it's a body corporate with its own objectives, provisions can be made there. At most, maybe somebody can make a claim of maintenance if they believe that they should have been looked after by the founders of the trust. The trusts are also beneficial in that they minimize conflict within families because it's a body corporate that's already been operating even before a person is deceased. And also usually trusts will have a provision around, this is the trust property. So you don't have the disputes of, but I was the wife, now you are taking the house and putting it into the trust. It already belongs to the trust. It does not belong to an individual. But also what it does, it is protects, trust property is protected. So for example, for argument's sake, if the wife goes on a spending spree and there are loans to be paid, trust property is not individual property, it's not marital property. So it becomes protected from, for example, creditors who may want to go after a particular individual, which is good if they're, minors or other persons who need to be protected. As I said, a trust is a body corporate, and you'll find that where estates have estate duty obligations, those of you that have probably dealt with, wills and inheritance of, family members, you will know that you pay what is called estate duty on the estate. When it's being wound up, there's a percentage that must be paid to ZIMRA or to KRA. While trusts will have tax obligations, they may not be as high as estate duty. So that's also the other benefit, that in terms of how much you are spending under your property for your beneficiaries, significantly it will be lower when you're dealing with trusts. And I think for those of us that are thinking, generationally, trusts are a better way of wealth management and managing inheritance for your children and for your children's children. So very, very briefly, as I said, I'm speaking to people that are born again, and I'm hoping that all of you will have a will so that we don't have to deal with intestate succession. But should we have to deal with intestate succession, which is where somebody dies and there is no will, what happens? In Kenya, we have what is called the Law of Succession Act. That is what manages how your estate will be dealt with when you are no longer there. In Zimbabwe, we have the Administration of Estates Act. We also have what is called the Deceased Estate Succession Act, as well as the Amendment Act. Now, Zimbabwean women will remember that way back in 1997, the then president himself actually led the 1997 amendment. That is the amendment that allowed women to be able to retain the matrimonial home in the case of customary marriages, because there wasn't that protection. So that is the relevance of that amendment. But in both Kenya and Zimbabwe, it's important to state that where there is no will, the law prioritizes inheritance by the surviving spouse or spouses, where that applies, together with the children, whether they are born in wedlock or out of wedlock, whether the marriage was, whether the marriage was a civil marriage, whether it was a church marriage, whether it was a customary marriage. So that is the underlying principle. The provisions of the law are that it is the spouse, the surviving spouse and children that inherit. In the absence of a spouse and children, then of course the estate will accrue, as I said, to the parents of the deceased first. If there are no parents, then it accrues to siblings. If there are no siblings, then we go down that, the bloodline, as it were, to find out who can inherit. Interestingly, in Kenya, a spouse only has a life interest in the inherited estate, which means that if they do not remarry, they're entitled to that part of the estate. They can keep it, they can do whatever they please with it. But once they remarry, they lose their life interest in it. In Zimbabwean law, however, a spouse inherits, particularly the matrimonial home and their portion of the estate, as a sole property. So in other words, they get it in their own right. So you inherit the property of your spouse, whether it's a husband or a wife. If it is the matrimonial home, you can go and get remarried. It will not affect your inheritance rights. The process of registration of an estate and distribution of an estate where there is no will takes pretty much the same format as where there is a will. The only difference is now people have to agree who's an executor. So for example, if you die and you don't have a will, all your relatives and all your interested people now have to sit with the master and you all have to collectively agree who is the best person to be executor. The same thing applies in Kenya when the grant for probate is applied for, then the court has to appoint who is the executor, who must be agreed to by everybody. So the disadvantage is that as the deceased person, you have very little control over who is managing your estate, and you leave so much room for contestation, which can be avoided. if you have a will. But the process is pretty much the same in terms of registration, in terms of drawing up the letters of administration, drawing up the distribution plans. Typically, you're also looking at, publication of the distribution plan and, of course, finally distribution of the estate. So very briefly, that's intestate succession, but that's a whole other conversation that would take more than an hour. And I see we have a minute before 8 o'clock. Thank you very much, Pastor. So you said, is there a value? So a testamentary trust is actually pretty much a combination of a will and a trust, because you basically say the residue of my estate for distribution should go into a trust. So it is kind of a combination really of a trust and a will. Is there a value limitation to the trust? Not really. There is no value limitation. I mean, you can set up a trust. If you look at people who've started NGOs, a lot of them actually say in the original trust deed, this trust deed is for the property value at the time is maybe even $50. I remember I was a trustee for one organization and we started with $100. So there is no limit to when you can start. Not really. And I think my personal preference, from a perspective of practicality, I think if you have a trust, you're probably better off having a trust, because then everything is managed. It continues to run, and there are no delays because of the registration and the formal appointment of executors, etc. But I suppose you could set up a will to say, my shares in the trust, I want them to be distributed this way. But once you've donated, property to the trust, I'm not sure that you have, shares. Maybe the best you can do is just do a will to say, my beneficiaries as stated in the trust will benefit as provided for in the trust deed. The two can coexist. It is not a legal challenge. It's not unique to Kenya. It's a global phenomenon. So what you find is that people tend to contest because they're like, oh, why did dad give this one the house and all I got was maybe, $2,000. And sometimes you can't question why somebody's giving what they're giving, right? So there is, of course, contestation that will always come, particularly from siblings who feel that they should have gotten more or they should have gotten what they consider to be equitable. But if a will can stand by itself, in the sense that it has been done by a person with a sound mind, they knew exactly what they were doing, then they can contest, but the will usually will stand if it's not an unreasonable benefit that has been given by the will. Technically, yes. Because when you inherit you inherit your portion. Pastor John, I saw the surprised look. When you inherit the property upon the decease of your spouse, you are inheriting it in your personal right. So if you then marry somebody else and that property becomes part of the matrimonial property in that second marriage, technically it should be, it should accrue. But I think I've found that a lot of people, when that happens, that's when people are coming up with trusts, but also people are coming up with wills to be able to take care of those things. Because remember, the law in Zimbabwe is that all marriages in Zimbabwe are out of community of property, right? Which means we don't necessarily jointly own things together. That is the law. We don't necessarily jointly own things together. But if you, for example, if I was widowed and I bought I inherited my late husband's property in my name, and then in my wisdom or lack thereof I marry somebody else and have their name put on the title deed of the property, they become a joint owner. And should I die, they'll be entitled to inherit as the surviving spouse. So one of the ways to ring fence that is to either have your will or to have your trust. You can, because the trust is a body corporate. Think of it like a company or an organization. So it can own, you can donate it, property that is owned outside of Zimbabwe. You just have to make sure that you clarify where it is and of course clarify your ownership of it. A sound mind is assumed unless there's a contestation. And usually contestation will come because people are saying, oh, we think that, the person was sick, or we think that the person was influenced. I've often found that it's adult children who turn around and say, oh, our father was influenced by the young wife, or our mother was influenced by her second husband. That sometimes happens, but a sound mind is assumed unless you contest it. How do you reduce executors' fees? I think one of the ways to reduce executors' fees is really to be very detailed in the drafting of your will, because if the longer the time that an executor spends managing the will, the more it will cost you, because you have to pay the executor fees and you are paying for their professional time. So I think that one of the ways to manage it is really to be very, very clear in your will, be very, for lack of a better expression, be razor sharp in your distribution, be razor sharp in who are your beneficiaries, and provide as little room as possible for contestation so that the estate is wound up as quickly as possible. There are some costs that you can't, you cannot limit. So if it's a big estate, there are costs that will come, management of the estate duty, that kind of thing. They will still come. A beneficiary would have a conflict of interest because they are benefiting from the estate. So it is not advisable to get an executor who's also a beneficiary. It happens sometimes. Families will agree, for example, that let the eldest child be the executor, but it always raises questions of conflict of interest. And I would say from a legal standpoint, you are better off with a removed person who is simply doing the job of managing with no direct benefit accruing to them. I think really what the discussion shows us is that, planning for the future is important. Ideally, everybody should have a will. Even better is to have a trust. As I said, I think in the discussion, the two can exist together. And I know that this is probably the shortened version of what needs to happen. So I would still come back and say my advice is when you then do decide to go the way of a will or the way of a trust, do sit down, speak with a legal practitioner, and they can guide you through the appropriate process for you. But I would still encourage for those people, and particularly for the demographic that I think I'm speaking to, I would really encourage that have a will. Where there's no will, have a trust, because it manages things for you better. And as I said, trusts tend to be more flexible in terms of access to, to your estate or access to the property in the event that you're no longer available. And especially when you have those that are vulnerable, dependent minors, people that are relying on you, you need to have a trust where the continued support can happen, unlike with the will where things may be, held up in the legal system for a season. So that would be my parting shot. Thank you. Thank you very much for watching. I hope you learned something. If you need any more information, my details are on the screen below, and we hope that we'll see you again.